It's an interesting story out of Wisconsin, because you've probably heard stories about female inmates who have complained because there are male prisoners who identify as female who have been housed with them. And in fact, the Biden administration has concluded that that result is required by the law. In some cases, courts have agreed with them, and in several states, they have adopted that as a matter of policy, that male prisoners must be housed with females if they identify as female. However, in this case, we have a Muslim prisoner who said it's a matter of religious freedom not to be strip searched by a biologically female prison guard, and the court agreed. I tried to describe the case. What am I missing there?
Yeah, so I think you described it fairly accurately. This is a significant case, however, examining the religious freedom standard that's applied when pitted against the claims of the gender ideology agenda, which are often advanced on the other side of religious freedom claims. We've seen obviously a lot of these cases domestically. This one is noteworthy because of the facts. You have, as you mentioned, a Muslim male prisoner who doesn't want his religious freedom rights to be violated by the claims of, on the other side, a transgender guard, biological females identifying as a male, but the guard being supported by the claims of the transgender agenda. So examining that, it is a very interesting case, and we're glad that religious freedom prevailed in this case, but it really is an indicator of where things are going to go in the future as more of these religious freedom cases pop up.
And Travis, of course, because this prisoner is a Muslim, and in the Muslim religion, there are very strict rules around who you can touch. And touching somebody of the opposite gender is a strong violation of many Muslims' understanding of Islam. And they never touch someone of the opposite sex that they are not actually married to or a relative of. So this would be a significant issue for them. But Travis, as I mentioned in the introduction, there have been many biological females who have been told they must share space in prison with biological males who identify as female. Do you think that this case would provide any help for them? Do those women just need to say they have a religious conviction against being housed with male prisoners?
It could provide help with them, and they should certainly avail themselves of the precedent being set here in the federal appeals court. You're really above the federal appeals court, just the U.S. Supreme Court, and this court relied on U.S. Supreme Court cases of a similar vein, holding that the Religious Land Use Institutionalized Persons Act, a federal statute that protects the religious freedom of prisoners, similar to the Religious Freedom Restoration Act, applies to protect prisoners like here. So they should be availing themselves of that statute's protections. In this case, you had the prisoner claim, look, I have a sincere religious belief that's been substantially burdened. If he can show those three criteria are met, and he did in this instance, then the government has to show it as a compelling interest. It's advancing through the least restrictive means. In this case, the Judge Sykes of the Seventh Circuit said, well, the government can say that advancing federal non-discrimination statutes, Title VII, and other statutory criteria, equal protection interests are compelling, but the prison did not do that in the least restrictive means, meaning it could have given this prisoner an exemption and still claim to adhere to Title VII. So examining that balance, you certainly would expect that prisoners who have religious freedom claims, again, sincere religious beliefs been substantially burdened. You have to show those three. You can't just, as the court, you can't just use this to claim anything. But if they can show that, the government has to prove its case. In this case, it did not meet its burden.
Now, Travis, there continues to be discussion and deliberation over the Equality Act in Congress. The left would very much like to get this into law. The conservatives, social conservatives, the Family Research Council, many of us who believe in religious freedom are very concerned about the Equality Act and what it would do. How would it impact a case like this one?
Yeah, I mean, the relevance here is the interest that the president is advancing here, steamrolling religious freedom, would those interests would be advanced by the Equality Act even against churches, religious nonprofits, and much more of what we think of as typically religious institutions or religious sectors of society, in addition to public spaces and public areas like prisons. So certainly, when you look at what is happening here, the Equality Act would take the prison's case, basically, and apply that, the prison's argument in this case, and apply it to many different areas. The Equality Act explicitly exempts RFRA, the Religious Freedom Restoration Act, from applying to claims in which that are governed by other sections of the Equality Act, basically the claims of the gender ideology agenda. So certainly in this case, though our LUPA is a separate federal statute, the theory would hold that our LUPA is irrelevant. The basis, the religious freedom basis of our LUPA, entirely irrelevant in this case if you apply the framework of the Equality Act to this fact pattern.
Yeah, and to bottom line that, now the Equality Act would essentially say that the rights of the transgender prisoner transcend the rights of the religious inmate in all cases as a matter of federal policy. And that would be, of course, very concerning. Travis, thanks for your time today.
Thank you.